Hello and good evening all. Welcome to this video, which is a lesson on the JOLT Effect, which is a framework that helps to address one of the most frustrating problems in legal and professional services, that being prospects who simply disappear without ever making a decision. My name's Will, DBA Lensler on YouTube, and as with all of these videos, it is a little bit of an after-hours drink along, so pause me for a moment, go pour yourself a glass of wine or grab a beer. I'm having beer since this is going to be a fairly quick video, hopefully. If you're not a drinker, perhaps a juice, I don't know. But anyway, JOLT framework is really a way of approaching that big problem monster where you have a consultation that goes really well, prospect seems engaged, they ask good questions, and then nothing. They just ghost you. And you're sitting there thinking, well, what happened? Everything seemed like it was fantastic. And most often the thing that we think of first is that they chose another lawyer. They chose another consultant. They chose another service of some sort. More often than not, though, they chose nothing at all. So this presentation draws from Matt Dixon's research on buyer indecision and adapts it specifically for legal and professional services practices. We're going to be mostly focused on the legal stuff since that's what my primary consulting work is in, but I will include some notes here and there about how you can adapt it to other professional services as well. And Matt Dixon's research shows that 60% of qualified prospects, almost 2/3 of your prospects, are lost not to competitors, but to indecision itself. So our goal for today is to make sure that by the end of this video, you're going to have a 4-step framework that you can use in your very next consultation to dramatically increase your conversion rate. And for my non-law firms that may or may not be watching this, while the examples are going to focus on legal practices, this framework does apply to any high-stakes professional service where clients are facing meaningful uncertainty, such as accounting firms that are handling business restructuring, financial advisors that are managing portfolios, consultants recommending organizational changes. Oh, look, that's me. Or therapists beginning treatment plans. The principle remains identical, and really as long as you are focused on selling some sort of service, and even if you're focused on selling some certain types of goods, the JOLT effect or the JOLT framework is useful in those types of sales. Once my arrow key works, we can get started. Okay, there we go. Most attorneys, and in fact most salespeople, are assuming that their biggest competition is other firms, law firms or otherwise, but the data tells a different story. And that data says that 60% of qualified prospects are disappearing into indecision. They came to the consult, they have a genuine need, and they can afford your services, but then they just disappear. Only 10 to 15% of those people who disappear are actually choosing a competitor. So think about what that means. For every client that you lose to another firm, you're losing 4 to 6 more to simple indecision. The real enemy that you're facing is the internal dialogue that your prospects have with themselves after they leave your office. They're not comparing you to other lawyers most of the time. They're wrestling with their uncertainty about whether making any decision, taking any action is the right one. It's very much paralysis by overanalysis. And the practical impact of this is that it shows up as prospects who seem interested, who seem engaged, but never return calls. Then when you send a follow-up email, that gets ignored. Or they say, I'll get back to you, or, oh, let me think about it, or, oh, I'll call you back, but they end up ghosting you. And ultimately, this all leads to very unpredictable, nebulous conversion rates that makes forecasting your revenue all but impossible. But the good news is that unlike competitive advantages, which require being actively better than other firms, obviously that's important, and we want to make sure that we're doing our best to provide those services, provide those advantages as well. Overcoming indecision requires different skills and skills that are entirely learnable. And that's what the JOLT framework provides. Decision anxiety usually comes in 3 different forms. Understanding which one your prospect is experiencing is going to change how you respond, because you can tailor your response to help overcome that decision anxiety. The first one is outcome uncertainty. The question of, oh, well, what if I make things worse? This is ultimately a fear of regret, worrying that action will make them worse off than staying in their current situation, even if the current situation is painful. Divorce is a perfect example of this from the legal perspective of, asking the question, what if fighting for custody damages my relationship with my kids? What if I lose my house? What if I lose my job? Etc. In estate planning, what if creating a trust actually ends up causing family conflict? It may well do, but it's still better than going through probate. In immigration, what if I file my case and then I get deported? Criminal defense, what if going to trial results in a worse sentence than if I submit a plea deal? In personal injury, what if filing a lawsuit makes my medical provider stop treating me? 98% sure that's illegal, but it's beside the point. The key insight is that these prospects aren't worried about choosing between lawyers. They're worried about whether taking legal action is actually the right move. And that's the real objection that you have to overcome from outcome uncertainty. The second one is information overload. I've talked to too many people. Most people these days are doing extensive research before they ever come into a consultation. By the time they reach you, they've often consulted with multiple lawyers, read dozens of articles, and talked to their friends about, maybe they've been in other certain similar situations and have referrals that they can offer. Every source is going to give them different advice, and thus they are paralyzed by choices rather than ignorance. And this is going to show up with phrases like, oh, I need to compare my options. Let me talk to one more lawyer just to get a final perspective. And they end up coming back with endless requests for additional information in trying to make a single decision. And then finally, you have recommendation confusion, saying, I don't know which approach is actually right. And this comes out of information overload, because when experts disagree, the prospect is going to freeze. If you have one lawyer that recommends mediation, you say to litigate aggressively, another person that they ask for advice suggests filing immediately, another says wait. The prospect is not the person who has the expertise to make the final decision between competing professional recommendations. They have not come to you because they want to see what might be out there. They have come to you because they know that they are out of their depth and lack the expertise to deal with the problem that they're experiencing. But the mistake that most attorneys make is that when prospects express uncertainty, we go in for, responding by providing more information, more options, more time to decide. And this makes all three types of anxiety worse because you're not providing them with a recommendation. For service-based businesses, these three anxieties appear pretty much across every strata. If you're a financial advisor, it's a question, what if I move my portfolio and miss the market recovery if things are down? Or consultants, I've gotten 3 different restructuring proposals. For accountants, one CPA is telling me to do this, another one says to keep my LLC. It all blends to one of these 3 different types of decision anxiety. And the JOLT framework is designed to address all 3 of these simultaneously. Finally, a transition that works. The JOLT framework provides 4 sequential steps that address decision anxiety systematically, not simultaneously. That would be ineffective. Each letter represents a specific intervention at a specific moment in the consultation. So you have 4 different steps in the JOLT framework. J is judge the indecision. Just diagnose before you prescribe. O, offer your recommendation. Tell them what to do. That's why they have come to you in the first place, because they need your expertise. L, limit exploration. Reduce their options. Don't provide them with everything under the sun that they could possibly think about doing. Keep it to 1, 2, maybe 3 options at the most. And then T, take risk off the table. Make it safe for them to proceed. And the reason why this sequence matters is that most attorneys, most people in service-based business sales, jump straight to offering recommendations without taking the time to understand the specific anxiety that the prospect is experiencing. You may have also heard this as selling the pain point. Or we jump to offering multiple options thinking that we're demonstrating flexibility and the ability to do whatever the person feels is right, but ultimately it's just leading them to paralyze their decision making. The JOLT sequence is designed to A, or number 1, since we're going to do this with numbers rather than letters because A is going to confuse us when we're talking about J, is to first understand the type of anxiety that is operating, then to reduce the uncertainty by providing clear direction, then prevent analysis paralysis by constraining choices, and finally removing the fear of making a wrong choice by taking risk off the table. The key principle in this is that the framework assumes prospects want you to lead them to a decision rather than explore options with them. They are hiring a lawyer for their expertise, not to be given a menu and told, oh, well, order what you want and we'll figure it out. In the same way that if you go to a restaurant that's got a menu that's entirely in a foreign language, you lack the knowledge to evaluate what you actually want to eat. So when do we want to use the JOLT framework? The JOLT framework is most powerful when you notice hesitation signals during or after the consultation. Phrases like, I need to think about it. Can you send me more information? I need to talk to my spouse or my business partner or my parents or whatever. Or, oh, I just want to get one more opinion. Most of the time, these phrases are indicative of decision anxiety rather than genuine objections. On the next four slides, we're going to break down each step with specific language and techniques that you can use immediately to help overcome each of these layers of indecision. For service-based businesses, the JOLT framework actually originated in sales research, but it applies perfectly to professional services. We can use it when prospects won't commit to a portfolio strategy, or when companies are endlessly delaying implementation. The principle is identical. Help your prospects overcome their internal barriers to making a decision. The J in JOLT, judge the indecision, means to diagnose the specific type of decision anxiety that your prospect is experiencing. You can't effectively address hesitation without understanding the source of the hesitation. And this matters because most attorneys assume that all hesitation is about either price or from their competition. But research shows that it's almost always about internal anxiety within the prospect. By asking diagnostic questions, we can reveal what's actually happening in the prospect's mind rather than just assuming what they might be thinking. And these diagnostic questions serve different purposes. Asking a question like, what's making this decision difficult for you, opens the door for them to discuss their anxiety without feeling sales pressure. And it signals that you understand that it's a difficult decision to make. You're not just expecting them to commit to it willy-nilly. Asking what concerns keep you up at night about this is similar. It helps to surface more of the emotional fears rather than the logical objections, and allows you to get a window into their psyche and help to understand the not necessarily more irrational things that are driving the decision, but the ones that can't necessarily be explained away with numbers and facts and figures. An example answer that you might hear is something like, oh, I'm worried that I'll destroy what's left of my relationship with my spouse. Of course, the key there is the phrase, what's left of my relationship, because if it was all good, then you probably wouldn't be coming to get a divorce, but that's beside the point. Third question, what would need to be true for you to move forward confidently? This helps you to identify their actual decision criteria that you will then speak to later on in the discussion to make sure that they feel that comfort in making the decision to say yes. So again, to continue with our divorce example, an example answer might be something like, oh, I need to know that my kids won't be harmed by the process. Perfectly legitimate concern. And then finally, the fourth question that you can ask, and these are, again, just sample diagnostic questions. There's tens and hundreds and thousands of them that are out there, and many different resources that you can look into that talk through all the different ways that you can ask these sort of discovery questions. Would be, is there something specific that's holding you back? This helps you to get to concrete obstacles rather than vague platitudes and uncertainties that most people will revert to when it comes to offering up objections. And to continue with our divorce example, you might hear something like, oh, my mother thinks I'm making a mistake. Sounds a bit like my childhood, be that as it may. And the things that you really want to listen for here are things like fear of regret. That's going to tell you that it's outcome uncertainty. What if this makes things worse? Oh, I'm worried about the consequences. What happens if we lose the case? Decision paralysis or information overload is going to sound like, oh, well, I've talked to several lawyers. There's so much information out there. I just need to do more research, or I'm not really sure exactly what, where I'm thinking of going. And then conflicting advice is going to show things like, well, I was told this by one person. Another lawyer told me this. My friend's lawyer took a different approach, and I'm just not sure which path is right for me. But through all this, there are some common mistakes that we want to avoid. The first thing is we don't immediately jump to solutions. We want to spend more time on the discovery than we may necessarily think is necessary, because sometimes people are warming up and trying to really get that feeling of comfort before they fully tell you the real crux of their issues. Similarly, don't dismiss their anxiety as irrational, because even if we think it is, it's not to them. To them, it's completely valid. It's something that they're concerned about. Finally, don't assume that you know what they're thinking. This is something that I'm really bad about sometimes, but ask the question about, is there something specific holding you back? What are the concerns keeping you up at night about this? Even if you think it's obvious, because sometimes it isn't. We all manifest our anxieties in different ways. So I know we already used a family law example, but if we're thinking about estate planning, you can ask, what's holding you back from completing your estate plan? Often it's going to reveal some family dynamic concerns or, cultural superstitions about planning for death. Again, particularly in the latter one, we may want to, laugh about that, dismiss it as being a little bit silly, but it's perfectly meaningful and valid to the person that holds those beliefs. In immigration, something like, what makes the visa decision process so stressful? It can reveal fears of denial or the consequences thereof, or confusion about which visa type they're actually eligible for. And that's ultimately why they've come to you, because you're the one who's the expert about it. Criminal defense could be a question like, what's your biggest concern about the case? It's often going to reveal fears of worst case outcomes or confusion about plea deals versus trial versus any of the other options that are open to you. For service-based businesses, if you're in the financial services industry, you might ask something like, what makes deciding about your portfolio difficult? Or if you're a therapist, what makes committing to ongoing sessions challenging? These are going to reveal either fears of losing your savings or confusion from competing advice, or vulnerability concerns or skepticism about whether or not therapy can actually help. The key to the judging the indecision step, the J step, is that you are collecting informations. You are not yet providing solutions. This is just a diagnostic phase that sets up everything that follows. 2 in a row. Getting better at this. The O step in the JOLT framework is offer your recommendation. Tell them what to do, because they've come to you for expert guidance. So clearly tell them what you think they should do. This is usually the most counterintuitive step for many attorneys who are trained to just present options and let the clients make the decision, because they think they will choose what feels most comfortable for them, and that will equate to a happy client. But we have to remember, the clients don't always know what the heck's actually best for them. And the core principle is, when prospects are anxious about making a decision, giving them more choices is just going to increase their anxiety. They need you to help reduce the uncertainty by recommending a clear path forward. And weak approaches fail because it forces someone to make a decision that they are fundamentally not capable of making in an informed way. Asking someone a question like, what do you want to do? You're forcing an anxious person to make the exact decision that they're struggling with. They hired you to guide them, not to mirror their uncertainty back to them. Saying, we could try A, B, or C. 3 paths is bordering towards information overload. It really depends on the circumstances, whether you just offer 1 or 2, or offer 1, 2, or 3. But when the prospect is lacking the expertise to evaluate which is best, offering 3 paths for them to choose from is just going to trigger information overload. Asking, what are you comfortable with? That invites them to choose based on comfort level rather than the optimal strategy. Comfort and correct are not usually aligned in legal matters because people are conflict averse. And in Dixon's studies, prospects preferred being told what to do over being given choices. One financial services firm increased their close rates by 27% simply by switching from "what would you like to do" as their final question to "here's what I recommend." So strong recommendations work because A, it reduces the prospect's cognitive load. You're giving them a clear path towards a solution rather than evaluating multiple options that may get them to exactly where they want to do. Number 2, it transfers expertise. Your recommendation is a signal that says, I've done this before, I know what works, it's going to work for you too. Number 3, it creates decision momentum. Once you recommend, the question shifts from should I do this to should I follow this expert's advice? And then 4, address outcome uncertainty. When you confidently recommend a path, you're implicitly saying this will work. It addresses outcome uncertainty. I apologize. So how to structure your recommendation. You start with your diagnostic link. Based on what you've told me, which is their concern that you discovered in the J step, I recommend blank. This is a direct connection from your recommendation to their stated anxiety and how it can be solved. Then you bring in a clear action. We're going to start with phase 1. We'll handle this, that, and the other, X, Y, and Z. And that way you're presenting specific actions rather than vague concepts. You're telling them exactly what the first steps towards their better future are going to look like. And then the rationale is that you provide a rationale saying this approach addresses your concern about their fear that you discovered in the J step while still achieving their goal, that vision of a better state. Not only does this help show that you heard their concerns and their pain point, it also shows that you've taken the time to think through their situation and present a recommendation that is tailored to them. And ultimately, the things that we have to remember here are you are making a recommendation. You are not giving them an order. It's not a command. If they push back, they still have some concerns that you may want to explore. But explore those concerns. Go back to the J step, but lead with confidence. Your recommendation should be based on their stated situation and on their stated concerns, rather than generic advice. There will be some instances, not many, but there will be some instances where people genuinely need options, and that's the point where you explain why multiple paths exist and still provide your recommendation for the one that you are leaning towards. And the key here is recognizing that the expert guidance that you are here to provide is going to reduce the anxiety for your clients who are struggling to make decisions in the area where they lack knowledge. The L step, limit exploration, means actively constraining the prospect's options to prevent endless information gathering and comparison shopping in hopes of some, silver bullet option that allows them to have their cake, eat it too, alongside a diamond encrusted aircraft carrier and a chocolate covered lap dance. This is counterintuitive though, because we always feel like we're trying to reduce their feeling of agency. But research shows that it accelerates decisions and gets you to that close faster without any negative impacts if it's done correctly. And really, it comes down to the paradox of choice. Barry Schwartz did research that demonstrated that more options typically leads to worse outcomes and decision paralysis. And this is especially true for complex, high-stakes decisions where the prospect lacks the expertise to evaluate choices. And thus, shopping around is dangerous. When prospects say, "Oh, I just want to go get one more opinion," or "let me talk to another lawyer or a couple more lawyers," they're not typically comparison shopping in good faith. They're delaying a difficult decision based on their own insecurities and creating more information for them to process, or gathering more information for them to process. Because each additional consultation that they undertake provides conflicting advice that's going to increase their uncertainty. It resets their emotional state back to confusion. And it makes your original recommendation feel less certain. Thus, the timeline is extended during which their life circumstances can change, and this not only really reduces the value of your original recommendation, but it could put them in an entirely different situation which can become even more complicated and more expensive to solve. So encouraging prospects to take their time and explore all of their options feels client-friendly, but for prospects who are already anxious, it's really pretty cruel, because you're extending their period of uncertainty and increasing the likelihood that they never decide at all when you have a solution that will work for them. So some of the phrases that come about very commonly, but don't work. Take as much time as you need. Make sure you explore all your options. Talk to other lawyers. Review all the information that I sent you. Oh, I encourage you to research all your options carefully. These phrases all sound respectful. They sound like you are trying to be supportive and kind about their autonomy, but you are enabling them to be indecisive and continuing that cycle of anxiety. So, the limit exploration technique is to present two options. Option A, proceed with your recommendation. Here are the specific next steps. Option B, don't proceed. Here are the specific consequences if you don't proceed. That's it. Almost always, there is no need for a third option. No, maybe explore other approaches, or if you feel like doing something different, we can try this as well. Just offer a clear binary choice. Your script is going to sound something like this. You have two paths forward. We file specific action by specific date. This means specific outcomes with specific defined timeline. Path 2, we don't proceed. This means specific consequences, and you'll need to find an alternative path. I do not recommend talking to more lawyers at this point. You're going to get different advice that will make this decision harder, not easier. You need to decide whether my recommendation makes sense for your situation. End script. That last bit can come across as a little bit forceful, and I would encourage you to tailor exactly how that sounds based on the feelings that you're getting in the consult, but you need to make that active statement of limiting choices based on your recommendation. And this works because A, it creates clarity. Only two options are easy to compare. 10 options, it's impossible even for most experts. 2, it forces a decision. When you explicitly limit exploration, you're saying, you've done your research, that phase is over, now it's time for us to make a decision. Even if they tell you no, at least there's the certainty, and you can move on with your life. 3, it establishes urgency. By framing it as a binary choice, you help to create that momentum to move forward. And then 4th, it demonstrates confidence. In limiting their options, you're signaling that you're certain about their recommendation, or about your recommendation. And to them, you're the expert. You're the person who should be making the recommendation anyway. A few practice area examples just to fill time. For family law, it would sound something like, you have two choices. You can file for divorce this month and you'll control the timeline, or wait and risk your spouse filing first with a more aggressive strategy. I don't recommend consulting more attorneys. You'll get 5 different opinions that'll confuse matters. Let's decide based on your actual situation rather than hypothetical alternatives. In estate planning, you'll say something along the lines of, your options are to create the trust structure now while you're healthy and can explain your reasoning to your children, or you can do nothing and continue without a plan. Consulting more estate attorneys is just going to give you different trust variations that will all accomplish the same basic goals, which is security for your future after you pass. The question is whether to act, not which exact structure to use. In immigration, say, again, you've got 2 paths. You can file an EB-2 now with your current credentials, or delay while you try to strengthen your application. Additional consultations will not change your basic qualifications, and therefore the question is whether your current credentials are sufficient, and I'm telling you that they are. Simple, to the point, straightforward. Criminal defense, say something like, oh, you can accept the plea deal the prosecutor offers, or we go to trial. Getting more opinions is not going to change the evidence or the law. Other lawyers might have different risk assessments, but those are based on the same facts that you and I have discussed. The decision is whether you trust my evaluation of the evidence. This places the onus upon the individual to make the decision about, is this expert truly an expert in the way that I was expecting them to be? And if you're good at your job, then you should be. But sometimes we're still going to get pushback. If they say, oh, I really want to talk to one more lawyer, you respond with something like, I understand, but what specific question do you think another lawyer will answer that we haven't covered? Often that's a sign that you're not comfortable with the recommendation itself, which is different from needing more information. Or if they say, I need more time to think, you can respond with, of course, but I want to be clear. More time to think and more research are very different things. Take time to consider whether you trust my recommendation, but additional research typically increases confusion rather than creates clarity. If you're in service-based businesses, you might find yourself as a financial advisor saying something like, you can move your portfolio to the allocation that I recommended, or keep your current holdings. Meeting with 3 more advisors is just going to give you 3 more options and make this decision that much harder. The question is whether you trust my analysis, not whether there's a perfect portfolio hiding out there somewhere. If you're a therapist, well, we can start weekly sessions to address your anxiety systematically, or we can meet occasionally when symptoms are acute. Consulting more therapists will give you different therapeutic modalities, but they all require the same fundamental commitment. The question is whether you're ready to commit to treatment. And none of this, even though it feels a little bit manipulative, is actually manipulative if your recommendation is genuinely in their best interest based on the facts that they have told you. You're not limiting options in order to trap them. You're limiting options to help them escape their analysis paralysis. And there's a huge difference between contrasting choices to close a sale and constraining choices to help an anxious person make a decision that they need to make. And then the final step is step 4, take risk off the table. This one requires a little bit more of a judgment call, but it's the final step that addresses the prospect's fear of making an irreversibly wrong decision. Even after you've diagnosed their anxiety, offered a recommendation, and limited their exploration, many prospects will still hesitate because they're afraid of commitment. The important insight here is that prospects aren't actually afraid of your service. They're afraid of being trapped in something that doesn't work. Your job is to create legitimate exit ramps that are going to make moving forward feel reversible. So you've got 4 risk removal strategies. There are others, but these are some of the most common ones. First one is phase-based billing. Structure your engagement in distinct, discrete phases that have natural decision points. This transforms from should I hire you for the entire case into should I hire you for the first phase, at which point the onus is upon you to provide a sufficiently positive experience that they never even think about, oh, should I hire them for the rest of the case? It's just, we got the first one done, what's next? Number 2 is satisfaction guarantees. Offer a money-back guarantee on specific early deliverables. Don't make it a blanket guarantee. This creates a moral hazard, possibly an ethical one, and frankly, it's a good way to lose money. But offer a targeted guarantee on early stage work. Some of these things could look like, if you're in estate planning, if you're not satisfied with the design after our design meeting, I'll refund the consultation fee. You don't want to give away all the money for the work that you did, but you can at least give them back something. In immigration, if after reviewing your documentation, I determine you don't qualify, I'll refund 50% of the fee. In family law, if my case assessment memo doesn't provide value, I'll refund the assessment fee. Something like this that allows them to see that you're willing to put some effort in for their satisfaction and to really help build that trust. What you don't want to guarantee, or what you want to not guarantee, depending on how you want to structure that semantically, is case outcomes, obviously, because those are fundamentally outside of your control. Obviously, you can have an influence on them, but be that as it may. Third option is to offer unbundled services. You can allow clients to purchase smaller, discrete services, not in all circumstances, but in many, before committing to full representation. This is especially powerful for prospects that have outcome uncertainty, who need to kind of test whether legal action makes sense. If you're doing estate planning, you can say, well, we can do just the consultation and plan design memo. That'll be $1,500. You can then take that to any attorney to implement after the fact if you're not satisfied. In immigration, maybe just an eligibility assessment and document review. Then you'll know if you qualify before you spend money on the applications themselves. Family law, initial consultation and strategy memo that'll cover your custody options would be $1,200. You can implement it yourself or hire another attorney if you're not satisfied. And then 4, defining clear success metrics. If you define exactly what success looks like at each stage so that the client knows when things are working, you're going to have much greater success with them throughout the length of your engagement. Frankly, even if you get nothing else from this presentation about sales or anything else like that, define those clear success metrics for your clients at some point during either the sales process or their onboarding as a client, because that is going to make your life so much easier because they are going to know what to expect. And I'm just going to leave that one there for a minute, because setting expectations is the most critical single thing you can do to ensure client satisfaction. People will put up with an incredible amount of things if you define what success looks like and what they can expect beforehand. And the most effective approach to all of this often combines multiple risk removal techniques. So you can say something like, let's start with phase 1. I'll evaluate your case and provide a written strategy memo for $1,500. If you're not satisfied with the analysis, I'll refund half of it. If you are satisfied, we'll apply that $1,500 to phase 2 representation. And then you'll know within 30 days whether this approach makes sense. So here you've combined phase-based billing, phase 1 versus phase 2, partial satisfaction guarantee, $750 in refund, a clear success metric, written strategy memo within 30 days, and a forward commitment credit, which applies to phase 2. And the reason that this step is last is because you can't lead with risk removal. Oh, don't worry, it's a money-back guarantee, because it sounds desperate. I know if you're in PI, you can't charge anyway, and the, no fee unless you win is par for the course. But for everybody else, you can't lead with risk removal because it just does sound desperate. It only works after you've already diagnosed their specific anxiety, J, provided clear direction, O, prevented endless research, L. Then you can, T, take risk off the table. At that point, addressing remaining commitment fears is pretty much natural. If you're in service-based businesses, again, same principles apply. If you're a financial advisor, you can say start off with a 90-day trial on a new allocation. If you're not satisfied with the performance after 1 quarter, we can revert to your previous holdings. If you're a therapist, let's commit to 4 sessions. After session 4, we can evaluate whether this approach is working. If you're not seeing progress, we can discuss whether to try a different modality or pause treatment. But the important thing is to understand that none of these are gimmicks. They are legitimate ways to reduce risk and make it easier for prospects to start. And you should honor every commitment that you make, because that's what makes this technique operable. A few more examples on how to combine all the JOLT steps to work together in a real estate planning scenario. Obviously, I'm scrubbed all the serial numbers off and kind of built this as a composite based on actual cases. We had a 68-year-old business owner. He had a $2 million estate and 2 adult children. He attended an initial consultation, seemed engaged, and said the immortal, horrible words, "I need to think about it." Absolute classic indecision pattern. What most attorneys would do, and in fact, the approach that this attorney wanted to take, was send a follow-up email with some more information about different trust options, offer to answer any additional questions, and wait for the client to call back. Maybe they'd do, one follow-up in a week or 2 just to see if they'd had, the opportunity to think about it. And as a result, the client never decided. They died. Yes, Will, that's it. They died without any sort of estate plan, and everybody had an absolute hell of a time in probate. Now, if you had taken the JOLT approach, what that would have done differently. In step 1, you would judge the indecision. Instead of assuming that the hesitation is about price or needing more information, you'd ask a diagnostic question. What's your biggest concern about moving forward? This answer would have revealed outcome uncertainty. He was worried about family conflict. His daughter would see unequal distribution as favoritism, even though his son helped build his $2 million business. And he feared creating the exact problem that he was trying to prevent, which is family harmony. This is an emotional reaction, not a logical one. More information about the way a trust is structured is not going to help address it. But now that you've judged the indecision, you can move to offering a recommendation and provide a specific solution that addresses his stated concern. If you create a trust that distributes equally now, eliminating the favoritism issue, but include a side letter explaining your reason about the business contribution, then we can also facilitate a family meeting where you can explain all of this while you're alive. And look at the specificity. There's a trust structure, there's documented reasoning, there's a communication vehicle, and there's timing, which is, while he's alive to explain. And so this isn't, here are 3 trust options, what sounds best to you. It's, here's what I recommend, and here's why it solves your specific concern. Step 3, limit exploration. You frame it as a binary choice. Plan now while you can explain your reasoning and maintain family harmony, or leave it to chance after you're gone when your kids can't ask you questions. Unless they're particularly good with a Ouija board, I suppose, but be that as it may. This helps to eliminate some of the common objections like, let me consult another estate attorney, I need to do more research on trust types, let me think about this, etc. Because the choice becomes clear. You can have a controlled explanation now, or you can have an uncontrolled interpretation later after you're dead. Frankly, depending on one's beliefs in the afterlife, you're dead, it doesn't actually matter, but we enjoy the peace of mind while we're alive. And then step 4, take risk off the table. We want to address any remaining commitment anxiety with phases and a partial guarantee. Say it's a $4,500 total package. Start with phase 1, plan design, and first draft for $2,500. If you're not satisfied with the plan design, we'll give you back $1,000. You're not committing to the entire $4,500 today, just to seeing what the plan looks like. Then you provide perspective. The real risk is not the $4,500 fee. It's the $2 million estate creating a family war because you waited. And this helps to reframe the risk from, what if I waste $4,500 to, what if I let this situation continue unresolved? Or if it never gets resolved? And the net result is the client signed that day, scheduled the family meeting for later that month. The family meeting went well because the equal distribution eliminated the favoritism concern, and the father's explanation addressed the business contribution question while he was alive to answer the follow-ups. And probably get ribbed a little bit about it at Thanksgiving dinner, but that's okay. Now, why did this work? Each step built on the previous one. J identified the emotional obstacle, family conflict. O provided a specific solution, equal distribution plus explanation. L prevented the research paralysis, do it now or risk it later. And then T removed commitment anxiety, a phased approach, and a partial guarantee. Without the full sequence, just offering the recommendation without the J, understanding concern, might have recommended unequal distribution since that is the economically logical course. Just J plus O without L allows, let me think about it, to turn into endless delay. And just JOL without the T leaves the commitment hurdle unaddressed. Okay, if you're in criminal defense, let's say you have some, before we do that, you have some unique challenges because the stakes are extraordinarily high. And more so than pretty much any other practice area, the anxiety that your client is feeling is very, very rational. Prospect of jail time, permanent record, you're creating legitimate outcome uncertainty here. The situation we have is a client was charged with felony drug possession. Prosecutor offered a plea deal. You could plead to reduce the charge, 2 years probation, felony record. Alternative was going to trial, where conviction could mean 3 to 5 years in prison. Client was paralyzed between two bad options. Challenge here is that this isn't really a case where one option is clearly correct. Both paths have significant risks. If you accept a plea, you've got a guaranteed felony record, you've got probation requirements. If you go to trial, you've got a much worse sentence if you're convicted, but you also have a chance of acquittal. Most defense attorneys present this as, here are your two options. You need to decide what you're comfortable with. Which, I can see the logic in that, but at the same time, the client is already not having a great week. And you presenting them with, here, make a decision about what your future is going to be, is going to absolutely paralyze them because they, again, do not have the expertise to evaluate a true trial risk versus plea certainty. So, JOLT in action, you want to judge the indecision. First, ask, what's the biggest concern? The answer is going to reveal that they're not comparing two legal strategies. This individual is comparing two futures for his life, neither of which he wants. It's classic outcome uncertainty, but amplified by fear of regret. What if I make the wrong choice and destroy my life? And there's commentary here. But the key insight is he wants you to tell him which future is less bad. He does not want to be responsible for choosing wrong. Now, offer your recommendation. Based on the evidence, here's my recommendation. We should reject the plea deal and file a motion to suppress the search. This is different from, you could accept the plea, or we could go to trial. You're recommending a specific legal strategy, a suppression motion, based on a weakness that you identified in the prosecution's case, which was insufficient probable cause. Why this recommendation addresses his anxiety is pretty straightforward, because it's based on specific legal analysis, not a vague hope of, we might get it overturned. It helps to create that decision path that is not binary, plea versus trial, and it reframes the choice as pursue a winnable motion rather than take a gamble on trial. The key phrase here is, if the motion succeeds, this case likely gets dismissed. If it fails, we can still negotiate a better plea before trial. This transforms the decision from accept bad outcome A or terrible outcome B to pursue a strategy that might eliminate both bad outcomes with a fallback position. Your L is limit exploration. Your choices now are to accept the deal and definitely get a felony record, or pursue the suppression and potentially walk away with no conviction. You can then add, there's no strategic benefit to accepting now. If the suppression fails, we still have an opportunity to accept this deal or negotiate a better one. This prevents the phrases like, let me talk to another criminal defense lawyer. I need more time to think. What if we tried something I read about on the internet? The limiting, however, isn't arbitrary. You're explaining that accepting now closes off better options, while pursuing suppression can help to keep those options open. And then finally, T, take risk off the table. Phase 1 is a suppression motion in hearing. Let's say that's $7,500. If we lose that motion, trial prep is phase 2, but we're not going to talk about trial fees until we see suppression results. This addresses the individual's fear of committing to a $25,000 trial only to then lose it, because he's not committing to a trial. He's committing to a suppression motion that might eliminate the need for trial. And the risk reframing is the $7,500 is going to buy you a real chance at dismissal. The alternative is accepting a guaranteed felony record without testing the weakest part of the prosecution's case. And the result here was that client retained for the suppression motion. The motion was successful. The evidence was suppressed due to insufficient probable cause. Case dismissed. And client paid $7,500 instead of accepting a felony record. So jobs are good and for everybody. Even if the motion had failed, the client would have been in the same position to negotiate a plea deal, but they would have already tested the prosecution's case and potentially identified additional weaknesses to use as a negotiation leverage. The reason the JOLT framework worked in this case is because it helped to convert two bad choices into a strategic sequence with multiple decision points. Before JOLT, you had option A, you could accept plea and get a felony record, or option B, you'd go to trial and risk prison. After JOLT, you had phase 1, test the search through a suppression motion. If it was successful, your case was dismissed. If it was unsuccessful, we're pretty much right back where we started, but with more information. And this made the decision psychologically manageable. The client wasn't choosing between two bad futures. He was able to choose between pursuing a specific legal strategy, or he was able to choose to pursue a specific legal strategy that had the possibility to eliminate both bad futures. All right, I know we're getting a little long on time, so let's talk through immigration real quick. We had a client with a PhD in strong publications that qualified for an EB-2 national interest waiver, but was hesitant to file. It's not an uncommon situation for highly skilled immigrants. Through the J stage, our diagnosis was that the concern was not about qualification strength. It was about the fear that filing would trigger heightened scrutiny, maybe an audit, an investigation, or adverse immigration action. Not unsurprising given these, the times that we're in right now. And this is legitimate outcome uncertainty, because the question is, what if trying to improve my situation ends up making it worse? The recommendation that we offered was that I recommend that we file an EB-2 NIW now. Your credentials are strong. You've got 3 peer-reviewed publications. You've got a PhD from a top-tier university. Employment in critical infrastructure. You meet all 3 of the prongs for a national interest waiver. This works because you're making a specific reference to their credentials and the legal standard that demonstrates that you've evaluated their case. You're not just trying to, generate a filing fee. L, limit exploration. You can file now when you're eligible or wait and risk law changes. The immigration context makes this particularly powerful because immigration law changes, all the more frequently these days, but even before the current administration, quite frequently through executive orders and policy memos. Wait is not a neutral option. It's a gamble that the law stays favorable, which is frankly not a great gamble. Alternatively, you could frame it as, you could consult 3 more immigration attorneys, but they'll all evaluate the same credentials and reach the same conclusion. The question is not whether you qualify, it's whether to file while you definitely do. And then T, risk removal. You can approach it as phase 1, the petition preparation and filing will charge you $5,000. If USCIS comes back with an RFE, phase 2 is response, that'll be an additional $2,000. This addresses the fear that you're committing to unknown costs if the case becomes complicated. Most EB-2 cases either get approved or generate a single RFE. By separating the RFE response into phase 2, you're capping your phase 1 exposure as well as theirs. Additional risk removal that you can try in immigration is also, you can say something along the lines of, if after reviewing your complete documentation, I determine you don't meet those NIW standards, I'll refund 50% of the fee and I'll explain why. Because this addresses one of the other most common specific immigration anxieties. What if I pay for a petition that was never going to work? And then finally, family law. Situation we have is a contested divorce with custody issues. Client wanted custody but feared that fighting for it would harm their children emotionally. Very common paralysis in high conflict divorces and quite an understandable one. Working through the JOLT framework, the diagnosis question, what makes this hard? They were worried about harming their kids emotionally. Again, very understandable. This is outcome uncertainty paired with moral anxiety. The client was afraid that fighting for custody was going to make them a bad parent, even though not fighting might mean losing custody. So the offer recommendation step, the O step, was to file for joint custody first. This helps to establish your rights without being overly aggressive. And this works because you're reframing fighting for custody as protecting your parental relationship rather than fighting for custody. Filing for joint custody isn't asking for more than you're entitled to, it's preventing loss of what you already have. Some additional framing could be, your kids need both parents involved. Filing for joint custody helps to protect that. It's the other party who needs to then argue against joint custody. L, limit exploration. Say something like file first and control the timeline, or wait for your spouse to file and then respond to whatever strategy they came up with. In family law, this is particularly powerful because filing first provides genuine strategic advantages. It helps you to control the venue. You get to set the initial custody framework. It forces other parties to respond rather than initiate, and it demonstrates commitment to maintaining parental roles. Point of clarification here, I'm not an attorney. None of this is legal advice. You're supposed to be watching this if you're an attorney looking for sales advice. These are just examples. Disclaimer over. Alternative framing could be something along the lines of, waiting won't make this easier. Your spouse's attorney is likely telling them to file soon. The question is who sets the initial terms. And then T, risk removal. You can say $4,500 will get you through temporary orders, although I do, as a business consultant, recommend against doing any sort of flat fee for family law cases. If you can put it in a very specific staging, you can usually get away with a flat fee. So $4,500 will get you through temporary orders. If you settle at mediation before a temporary orders hearing, we'll refund your unused funds because this is all trust accounting. And this will help to address the fear of committing to extended litigation. Most family law cases are going to settle after initial pleadings or at temporary orders at the most. By offering a refund of unused funds, you're doing what you're supposed to do if you're, putting it in an IOLTA, and you're making the commitment far more reversible. You can also remove risk additionally by saying something along the lines of, let's start with filing and one settlement conference attempt. After that conference, you'll know whether settlement is possible. If it is, you haven't spent any money on trial prep. If it's not, you've already got the advantage that you've established your position. So our final slide before we get to our action plan is to summarize what not to do. Some common mistakes. Don't resell your value when they stall. This has an 84% failure rate because when a prospect says, I need to think about it, most attorneys just respond by reemphasizing, ooh, my qualifications, ooh, my experience, oh, my firm's strengths. This doesn't work because the hesitation is not about whether you're qualified. You already have the JD. Your name might be on the door. Your diploma's on the wall. They know that you are qualified. They probably did enough research to know that you've got X number of Google reviews and you've been in business for however many years. It fails because it assumes that the problem is that they don't value you enough. This is usually not the case. You're creating pressure when they need to reduce the pressure on them. It doesn't address their actual anxiety because you haven't found out what their anxiety actually is, and it makes you look desperate. And nobody wants desperate. The research shows that this has an 84% failure rate as an approach. When prospects stall, adding more reasons to choose us does not help. What to do instead? Use JOLT to diagnose their actual concern, then address that specific concern with a recommendation, limit their exploration, and reduce their risk. Second one, you've made it through J, but then you start offering more options to help them decide. This is just going to create more paralysis because when prospects seem uncertain, we so often try to be helpful by just saying, oh, well, here's some other things that you can try and hope that one of them sounds like a better option to this individual. But this fails because you're increasing the cognitive load on the individual at the exact moment that they need less cognitive load. It tells them that you're not sure about what the best path is, which undermines their confidence in your qualifications as an expert. And it also creates the paradox of choice. Having more options makes it harder to decide because they've now, instead of having one difficult decision to make, they have several. Paralysis isn't from a lack of options, it's from too many options that they don't have the expertise to evaluate. I know I've said it several times throughout this video, but nobody is coming to you because they just want someone to chat with. They're coming to you because you have the expertise that they lack to help deal with their specific problem. So instead, offer your one clear recommendation based on their specific situation. If they push back on that recommendation, go back to the J, explore why, but don't just proactively multiply their choices in the hopes that they're going to realize something else is a better option. Number 3 is pressuring for an immediate decision because desperation repels. Sometimes it can feel good to respond to hesitation with urgency tactics. Oh, this offer is only going to be good until Friday. Oh, my calendar's filling up fast. I need an answer today, or we're not going to be able to move forward with this. But more often than not, this fails because it signals desperation. It creates resentment. It makes them feel like they're being manipulated. It doesn't address their underlying anxiety. And you're kind of burning the relationship if they do decide to proceed, because they're like, I'm doing this because it was, forced on me. I did it under duress. Artificial urgency is pretty easy to see through, and it's incredibly counterproductive. Instead, you can help create that natural momentum through the JOLT sequence, particularly by limiting exploration in a way that shows the strategic cost of delay, rather than putting arbitrary pressure on them to proceed immediately. Some other mistakes that I didn't put on this slide, but I do want to mention real quickly. Assuming hesitation is about price, that's the most common objection that people will put forth. Sometimes it truly is about price, but more often than not, it's really more about some other underlying anxiety, and price is just an easy one to talk about because everybody's afraid to talk about money. Another mistake is just sending more information. Again, sometimes it can work, but email follow-ups with more resources, additional resources, are usually not going to convert stalled prospects. It can help keep people engaged in some ways if they truly need more time to think about it, but it is not your first option. And then finally, waiting for them to call back. They're not going to call back. If there's hesitation at the end of the consultation, address it then, or accept that you're leaving that consult unresolved and you've lost that client. Okay, finally, your action plan for, now this will probably go live tomorrow on Friday, so your action plan for next week. Identify your last 3 think about it consultations. So go back over your last 10 to 20, however long it takes you, to find 3 where the prospect seemed truly qualified and interested but didn't retain you. Think about what they said. They probably said something like, oh, I need to think about it. Can you send me more information? I want to get another opinion. And write down the elements of those 3 cases if you don't have the notes already. Then, go back through and try to figure out which anxiety type was each of those consults experiencing. Were they experiencing outcome uncertainty? Were they worried that the legal action would make things worse? Were they experiencing information overload? Had they consulted multiple lawyers or done extensive research themselves? Or were they experiencing recommendation confusion? Were they getting conflicting advice? Be honest about it. You probably assumed it was about price or them comparing firms. But was it actually decision anxiety? 3, for each of those cases, go and write out the recommendation that you should have given using the offer framework, saying something along the lines of, based on what you've told me about their specific concern, I recommend we, specific action plan with timeline. Practice making it specific rather than vague, confident rather than tentative, and linked to their specific concern rather than generic. Don't say, we could pursue several strategies depending on what you're comfortable with. Say something along the lines of, based on your concern about minimizing conflict with your co-parent, I recommend we file for joint custody and request mediation before the temporary orders hearing. And then step 4, create one risk removal offer. Design a risk removal mechanism that you can offer in your next consultation. Could be phase-based billing, partial money-back guarantee, clear 30, 60, 90-day success metrics, but make it specific to your practice area and make it real. It has to be something that you're actually willing to honor. And write this out word for word so that you can use it smoothly in your conversation rather than having to try and think about it on the fly or remember what you wrote down a week or 2 prior. Step 5 is the uncomfortable one. Everybody hates role play, but role play it with a colleague. Find another attorney or a staff member that you trust who won't just be sycophantic and tell you that, oh, this was all great, and practice the sequence. Go back and forth on playing the hesitant prospect. Go back and forth on diagnosing anxiety, delivering recommendations, practicing limiting exploration, and delivering the risk removal offer. Do it at least twice. 3, 4, 5 times is more effective. The first time's going to feel pretty awkward. The second time will feel a lot more natural. And then have them throw you curveballs based on their experience, either with conducting consults or what they've heard from others. And practice responding with those JOLT principles rather than reflexive defenses. It's okay to take a pause and think about your answer because ultimately it's still role play. But it's better to take the time and think about those answers now rather than try and figure them out when you're doing this live. And your goal for this month, it's March 5th. You'll be watching this, March 6th or a little later, is to close one consultation using the JOLT method that you would have previously lost to Indecision. Not close every consult, just one. That's it. Just one where you recognize the indecision pattern and successfully use JOLT to help them move forward. And if you do that once, you'll see it works, you'll see how it works, and you'll be able to replicate it. So track those metrics, track some metrics for the next 30 days. How many consultations did you have that exhibited hesitation signals? How many times did you attempt to use the JOLT framework? And how many of those JOLT attempts resulted in retention? You're not going to experience perfection because this is a skill that improves with practice, but you should see a measurable and meaningful improvement in your consultation successes. I know a lot of this has kind of felt like, ooh, it sounds a little manipulative when we're really playing with people's emotions or trying to move them into something that they wouldn't have done otherwise. But the JOLT framework is not manipulative. You're not tricking people into hiring you. You're just helping genuinely qualified prospects to overcome the decision anxiety that is otherwise preventing them from solving their legal problems. When someone needs legal help, when they have the means to get it, and they don't because of decision paralysis, that's a failure for both of you. And JOLT helps them make the decisions that they need to make. And the research backs this up. Prospects appreciate being guided to a decision more than being given endless options. Your expertise is valuable precisely because you can evaluate their situation much better than they can and recommend a path forward. If you use that expertise confidently and honestly, you'll close more consultations while providing much better service. And just a final couple of thoughts for service-based businesses, because I know I lost that plot a little bit through the examples phase, but this action plan does translate directly. Identify the last 3 prospects who didn't commit to whatever service you're offering, diagnose the anxiety type, write your recommendation statements, create your risk removal offer, and then role play it with a colleague. Because the principle is ultimately identical. You practice your framework on real cases until it becomes natural. That's my time, just over an hour. I thought this was going to take 20 minutes, so there we have it. But as always, thank you for your time this evening, or whenever and wherever you are watching, and I wish you all good night and a good tomorrow.